Well, one day after Virginia's Attorney General called for the U.S. Supreme Court to decide on an expedited basis whether this health care overhaul law is constitutional, the Department of Justice is saying no, saying that it will oppose any effort to streamline these appeals, which are now percolating up to the trial courts, to the High Court. Why? Isn't it better to get an answer from the High Court now and have it resolved one way or the other? Chip Merlin is a trial attorney, and Jason Lewis is a syndicated radio host and author of Power Divided is Power Checked. All right, gentlemen, so it's very rare for the Supreme Court to allow this, to say, okay, because in the federal courts, you got the trial court, appeal court level, and then the High Court. And normally you got to go up that order. But sometimes it will allow you to skip that Court of Appeals and go right to the Supreme Court. The point is that the DOJ, Jason, is saying, no, we're not even going to join in the request to have the Supreme Court decide it right away, so why not?
Right. Because they're afraid, and what they want to do is get a head of steam up, try to get some of the law implemented. Most of the goodies of the law don't start till 2014. I don't think they'll be able to hold it off that long. But the more these Medicaid rolls fill up, the more health insurance exchanges that are put in place, the more momentum they've got. And as much as we don't like to admit it, Megan, the Supreme Court does take into consideration, however subconsciously, popular opinion. You remember during the New Deal when Roosevelt threatened to pack the court, it was called the switch in time that saved 9. The court did a 180 on New Deal legislation and upheld it. So there is political pressure that can be put upon the court.
Chip, is there an argument that this is anything but political? Because everybody, lawyers on both sides of the aisle, agree the Supreme Court is going to decide whether this health care law is constitutional or not, ultimately. It's not going to be decided by the lower courts once and for all. So why not? Why wouldn't the administration be in favor of just letting them do it and letting them do it soon?
Well, this is all about politics right now. The politics has really been driven by the opponents of the health care bill itself. It's the Attorney General of Virginia that's pushing for this because it's a no-lose situation for them. They have already won. They don't have to worry about going through the appellate court and possibly losing there. And the energy they've got in the media, with every doctor in the United States, small business people being against this particular bill, they want to come out very strongly in the media showing that they oppose it and want to get it to the Supreme Court as quickly as they possibly can.
What happens, in the meantime, though, Jason? Might the administration reverse itself? Because now you've got the administration lost 2 and it won 2. Right. And the places it lost were Virginia. So this guy in Virginia, this Attorney General, he wants it to go right up. He wants to get his victory affirmed. But also down in Florida, those 26 states sued over health care reform in Florida. Right. They won, and now the law has been declared void. Now some state governors are saying they are going to ignore the law altogether, Jason, saying it's been declared void. We don't have to do anything. So could the administration actually switch course on this and say, wait a minute, actually, we do need a ruling, and we need one quickly?
Well, I don't, it depends how they read the tea leaves, I guess, Megan, on this. I think right now the thinking of DOJ is we don't want to get anywhere near this. Right now it's the law of the land, as the trial attorney says. It's got to go to the appellate route, and until it gets to the final arbiter, the Supreme Court, it's the law of the land, even though, and some of these governors may be told to implement this thing in other court edicts. But I tell you, this decision is so scary for the elastic commerce clause people. But, I saw you the other night talking about Lopez and Morrison. If this decision comes down in favor of the states, it will be a landmark decision for over 70 years. It will overturn Wickard v. Filburn, which gave us this elastic commerce clause, which says the federal government may regulate anything that affects commerce. Remember, in the decision, Vincent went beyond the notion that, well, okay, this isn't really commerce. This isn't really commerce. You're not regulating commerce because people aren't buying anything. He then went on to say, if this bill or this law is upheld, you could force people to buy GM automobiles because that has an effect on the federal government because we subsidize GM. That strikes right at the heart of the modern elastic commerce clause jurisprudence. Yeah. It could be the most important decision for federalism in 70 years.
Chip, let me ask you this. That decision in Florida where the judge said the individual mandate is unconstitutional, and as a result, the whole law fails. The whole law is void. That got criticized by the White House this week, which came out and said he's a judicial activist, and he overreached, and he's outside the mainstream. Jonathan Turley, no conservative lawyer came out and said, Chip, that's ridiculous, basically, to call this judge a judicial activist. The government has only itself to blame for this judge concluding that they are intertwined in an inextricable way. And he defended this judge. What's your take on it?
Well, it's a great point to bring. It's the opponents against the health care bill that are truly now promoting judicial activism. They're asking judges to overturn the law of the land by public decree from Congress.
How is it? But how is it? How is
in
it?
the past,
but is it judicial activism if the law is unconstitutional to ask a judge to overturn it?
No, because it's judges making law that's passed by the elected body that most opponents of judicial activism get so upset about. In this case, the irony is that they're asking for judges to overturn the law that Congress has actually passed.
Right, but the problem with that logic, Chip, is that it assumes the law is constitutional. Now, I don't know whether it's constitutional or it's not constitutional, but your argument is assuming that it is constitutional and therefore no judge should ever question it.
No, I'm not saying that whatsoever. As a matter of fact, as a trial attorney, I absolutely support the right of people to challenge laws as to whether or not they're constitutional. The point being is that typically these individuals who are against judicial activism are against judges making up the law and overturning what popular elected bodies put in place.
That's actually, I think you've redefined the two arguments, because normally when you hear the term judicial activist come out of a liberal's mouth, they're talking about what you're talking about, judges striking down statutes. When you hear it coming out of a conservative's mouth, they're talking about judges inventing law, stretching the law. They talk about Roe v. Wade, and, inventing or finding.
That's the whole point. That's the entire point. The rules are reversed. The rules are reversed in this particular case.
Go ahead, Jason.
Since incorporation doctrine, judges have been inventing and legislating from the bench on state issues, from abortion to medicinal marijuana.
Well, I don't want to make it into a big policy debate, but I want to ask you, because I feel like this Judge Vincent was thrown under the bus a bit by the White House, calling him an activist. And then I hear Jonathan Turley, a liberal lawyer, coming out and defending this judge, saying that's not fair. It's the administration who went in there and told this judge that this individual mandate is essential. It is an essential piece of the legislation. And then when this judge struck down that piece of the law, what choice did he have? That's what some lawyers are asking.
Right, exactly. It is the very essence of the judiciary to take a look and see whether the federal government has overstepped its specific enumerated powers. That is the precise reason for judicial review. That is not judicial activism. That is about as original as you can possibly get.
All right, guys, I gotta wrap it up. But good debate. We framed a lot of issues for the viewers. I hope they stayed with us through Lopez and Morrison. God, it gets, you get in the weeds, but those are all important Supreme Court cases on the Commerce Clause, which you can bet you're going to be hearing more about. Gentlemen, thank you.